Article 13 Mitigating Circumstance. Number 1. Those mentioned in the next preceding chapter, when all the requisites necessary to justify or to exempt from criminal liability in the prospective cases are not attendant. Number 2. That the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provision of Article 80. Number 3. That the offender had no intention to commit so grave a wrong as that committed. Number 4. That a sufficient provocation or threat on the part of the offended party immediately preceded the act. Number 5. That the act was committed in the immediate vindication of a grave offense to the one committing the felony delicto, his spouse, descendants or relatives by affinity within the same degree. Number 6. That of having upon an impulse so powerful as naturally to have produced passion or obfuscation. Number 7. That the offender had no voluntarily surrendered himself by a person in authority or his agents, or that he had no voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. Number 8. That the offender is deaf and dumb, blind, or otherwise suffering some physical defect, which thus restrict his means of action, defense, or communication with a fellow being. Number 9. Such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of the consciousness of his acts. Number 10. And finally, any other circumstance of a similar in nature and analogous to those above mentioned.